In Maine, a will that's not signed by witnesses is still valid if it's a holograph. We're not talking about a three-dimensional image created with fancy optics, mirrors, and the wonders of physics and geometry. That's a hologram. A holograph, or holographic will, is a handwritten last will and testament. Holographic wills might seem incompatible with preprinted fill-in-the-blank form wills. However, in Estate of Gonzalez, the Maine Supreme Judicial Court was able to reconcile them. Fermin Gonzalez visited his brother Joseph and his brother's wife Elizabeth to get their signatures as witnesses on his will. Gonzalez showed his witnesses 2 copies of a preprinted fill-in-the-blank form will. The form's preprinted provisions included a revocation clause, an executor-appointment provision, and a bequest provision beginning with a statement of testamentary intent reading, quote, "I direct that after payment of all my just debts, my property be bequeathed in the manner following," unquote. The first copy of the will was a draft. On the draft, Gonzalez had already filled in the blanks and written a detailed bequest by hand. He'd already signed the draft as well, but it lacked witness signatures. The second copy was blank and intended as the final version. Gonzalez explained to his witnesses that he planned to rewrite the handwritten information from the draft onto the final version. He asked his witnesses to sign the blank final version, which they did. Before Gonzalez had a chance to complete the final version, he died. 3 of the will's beneficiaries petitioned a probate court to admit the draft will to probate. They argued that although the draft lacked witness signatures, it was nonetheless valid as a holographic will. 2 people excluded from Gonzalez's bequest opposed the petition. After a trial, the opposition moved for summary judgment, arguing that the draft wasn't a valid holographic will because the preprinted statement of testamentary intent was material and had to be handwritten to be a valid holograph. The probate judge disagreed and denied the motion. The opposition appealed to the Maine Supreme Judicial Court.